So Abhijit and Ruchi, you are insiders, so you don't get it, right? Anyway, so let me now request Angus and Ankit, you also can join the panel now. And Angus Marshall is an Australian qualified lawyer, having graduated from Australian National University with Bachelor's degree of Commerce and Bachelor of Laws from the University of Sydney with Master of Laws. He is currently the manager of AIG's mergers and acquisition and transaction liability business in the UK, and he has illustrious career. He has worked for PricewaterhouseCoopers in their international tax and mergers and acquisitions group, and also at Norton Rose Fulbright in their mergers and acquisition practice. Angus joined AIG London in 2013 as a senior underwriter focusing on emerging markets in EMEA. Ankit is a senior member of M&A practice group in the firm. So I think let's start with that. But Simon, I'll get back to you right away. We have heard a number of fascinating aspects about macroeconomic environment in India. You know, at the outset it looks very good, and also in the M&A market. However, the cross-border deals are always fraught with challenges. One of the biggest risks which foreign investors perceive while acquiring business in India is regulatory risk. Who are some of the key regulators and they are likely to encounter in the deals in India, and what are some of the regulatory concerns one has to assess? So, Simon.
Sure. So I think in the M&A context, I think we can divide this into two bits, into regulators specifically, and I think we dealt a little bit of this previously, is in terms of how the law is sort of interpreted, which is another regulatory risk, really speaking. When you want to acquire a company in India, there are a few regulators that you're likely to encounter, or there are laws that you're likely to encounter. One is the FIPB. The FIPB is the Foreign Investment Promotion Board. What it does is that there are certain sectors in India that a foreign entity cannot really acquire more than a stated amount, or even a stated amount requires the approval of the Foreign Investment Promotion Board. The insurance sector is one such sector where more than 26% requires an FIPB approval. The pharma sector, the brownfield pharma sector is another such sector where any investment into a brownfield pharma, any FDI investment requires the approval of the FIPB. So the FIPB is one such regulator that one will encounter in specific sectors. If you're investing into a regulated environment like financial services, like telecom, like insurance, aviation, and so on and so forth, you have the specific regulatory bodies as well that you need to encounter. Sometimes issuance of capital requires the approval of that regulator as well. For instance, the insurance sector, anyone that acquires 2% or more requires the approval of the IRDA, which is the insurance regulatory body that controls or governs insurance companies. So that's the second regulator that you have. The third regulator, we talked about it in the last panel, is the Securities and Exchange Board of India. You encounter the SEBI if you're doing a listed transaction. That means if you're acquiring a company or doing anything to do with a listed company or listed on the bourses of the exchange. The fourth regulator would be, not really a regulator, but important statutory authority would be the tax authorities today in India, which I think are most famous across the world. And the fifth regulator that you would consistently encounter is the CCI, which is the Competition Commission of India. If you're doing a large transaction, you would certainly require the approval of the CCI. Now, is India sort of new or the only country that has regulators governing these aspects? The answer to that is no. Are these regulators extremely draconian? Not necessarily. The FIPB today is taking a very pragmatic view on certain things. So they are changing India mindset. But I think the problems or the hurdles that that acquirers face when coming into India is there is no real certainty of what the law really is. Since laws today, as Nishith pointed out, can be passed by bureaucrats and the regulatory authority themselves, it is easy for one to change things as time comes by, and therefore the biggest risk today in India is the fact that things are not really certain. For instance, we had a deal where a large US pharma company had signed up an agreement to acquire 55% of a India pharmaceutical company back in 2007, 2008. And there were certain milestones that needed to be accomplished. Now, by the time the milestone came to and it was going to be a phased acquisition. So the first acquisition was going to be 40%, and then so on and so forth. The minute, by the time they ventured on the third milestone, the law had changed, which required now for acquirers to seek the approval of the FIPB if you were acquiring any shares in a brownfield pharma company. Again, havoc, because the entire commercial discussion was to acquire 55 in a phased manner. So I think the biggest concern today for investors today is really uncertainty on what the regulation really is at the time that you invest and how it's going to sort of change going forward. The second concern on regulatory risks is interpretation of the law. I don't know if people are familiar with the story, but I think last year the entire concern, a deal that caused a lot of concern on what regulators were thinking was the Jet Etihad transaction. What happened here was Etihad was trying to buy a 24% stake in a listed company. Now, the aviation policy or the aviation FDI policy relating to aviation had just changed, where you could acquire now up to 49% in the strategic player could acquire up to 49% in the aviation sector, subject to FIPB approval. But the only condition was that you could not acquire control in that company. Now, Jet was a listed entity. The minute you acquire 25% and above, you need to make an open offer. The open offer component is 26%. So if an entity today acquires 25% in a listed company, it is possible that post the open offer, you would have more than 50% of that company. So, the deal could not be structured in any way other than, acquiring a minority stake less than 25%. But the concern is that Indian takeover codes don't just apply on a threshold of shares. It also talks about control. Now, there are three or four sort of regulators that are sensitive to what control really means, and there are various laws that define them. One is the takeover code. The SEBI interprets control in a certain manner. The FIPB also has this stipulation that if you acquire in the aviation sector, you can't really have control. And the third is the Competition Act, which also talks about control and defines control in a certain way. And if you acquire control over, and you meet the financial thresholds, you again need to make a filing before the Competition Commission of India. So the question was that you have three regulators. You have the same definition, by and large, the same definition spread across three regulations. And can one regulator really take a different view from another in this given context? Now. the SEBI, the entire concern here was not just the 24%, was the fact that in addition to 24%, the acquirer was also going to be getting certain affirmative rights, and certain and the ability to appoint certain management in the company. The question was this management sort of ability of Etihad, did it sort of change the entire concept? Was it also acquiring control? Two regulators said, we're okay with it. If you acquire 24% and you have, these limited rights, it's not control. But with a caveat saying that if any other regulator takes a different view, we have the right to reopen this situation. And lo and behold, the Competition Commission of India said, we don't really care what other regulators say. For us, this is a control deal. The minute you have an affirmative right, this is control. So the entire sort of concept, all the other regulators had to sort of, relook at their decision to see whether such a transaction was actually possible. So this is a risk that is being faced. Fortunately, the outcome of this is positive, where the SAT in its judgment on this aspect said different regulators cater to different contexts, and in different contexts you can have even the same definition meaning different things. So, the Jet Etihad transaction went through, but I think this is a huge risk that is consistently prevalent with regulators in India is discrepancy on what they really mean.
Good. And I just want to turn to Ankit now. I think Simon, of course, touched on some antitrust risks. What are specific antitrust trends and considerations? If you can just elaborate on that.
Yeah. So just on a lighter note, the term antitrust is one of those US globalized terms, but don't be fooled by that. We are much closer to the EU when it comes to the actual law than the term would suggest. So I think just to step back, I think what one needs to know about India specifically on the antitrust front. There's been a lot of news on the antitrust regulator in India, and there were a lot of concerns raised initially when the Competition Commission of India, which is the antitrust regulator in India, was being set up, that the 210 days waiting period is going to be substantial and is going to really impact M&A deals into India. Some of those fears have been allayed, and I'll come to why those and how those have been allayed. But as a regulator, in the last 4 years since its inception, it has been able to make its mark. It's almost sort of set up international standards in terms of its interpretation of the laws and the rules of the M&A game that it has been able to sort of set. Now, just on the law, if you're a foreign acquirer, what you need to know from an Indian antitrust perspective is that it's very similar to what is there in the EU, with some exceptions. In terms of jurisdictional thresholds, just like in the EU, you have a turnover test. You have a turnover test in India as well, but you also have an asset test. So if the assets and turnover meet a certain threshold, then you would require a pre-merger notification in India. Now, the pre-merger notification as compared to the UK is not a voluntary one. The moment you hit those thresholds, it's a mandatory notification, which is similar to what's there in the EU. There is a Polish type exemption in the Competition Act in India, which is essentially there's a de minimis exemption. So if the target enterprise, Poland obviously has a separate sort of de minimis exemption, but the concept is the same. So if you have a target which you're sort of buying, which has assets and turnover of less than 2.5 billion or 7.5 billion, then that transaction does not require a mandatory notification. Now, these are on the jurisdictional points and the requirement for a filing. I think what's very important and what we have seen international investors being more concerned about is really the timeline. And also, what is the scope of the investigations, how long the investigations are going to take, how is the CCI, which is the Competition Commission of India, going to define the relevant market. Now, one needs to understand something which is very peculiar about India. Though India is one country, India is comprised of more states than the number of members in the EU. So India has 29 states and 7 union territories, and in my last estimate there were 28 member states of the EU. So therefore, in terms of scope, in terms of complexity, the Competition Commission of India has to deal with a much larger and complex problem, because as you would notice with the GST debate, sometimes the Indian market may not be a single market, and therefore when you're assessing what risks it will pose to your deal, you need to ensure that you're very clear on the relevant market for that particular transaction. Now, once you make the filing, once you meet the jurisdictional thresholds and you make the filing, there is essentially a EU type phase 1, phase 2 investigations. The phase 1 is around, CCI takes around 30 days to make the determination, 30 working days, which is similar to EU, which has 25 days. And if the matter requires a further evaluation, then the matter is referred to phase 2 investigations. And again, in terms of statistics, in terms of the number of phase 1 investigations versus phase 2 investigations, it's very similar. In fact, EU has much more phase 2 investigations than India has had, but that has also got to do with the number of years that merger control enforcement has happened in the EU and the UK. So, I mean, the numbers in the EU is 91% of the cases are almost unconditional approval, and you have 4 to 3% of cases which goes into phase 2 investigations, or there is a sort of conditional approval that's granted. In the Indian context, there have only been 2 instances thus far where you have had a phase 2 investigations, and the remedial measures in both those cases has been divestitures, which is again very similar to what's there internationally. So, that's sort of there on the law. The waiting period is slightly more than what you would find in the EU. In India, but those have been in rare instances. In India, the waiting period is 210 days. That is assuming you go into the phase 2 investigations, whereas in the EU, it's around 180 days. So therefore, on some of these points, they're very similar to the EU concept. So somebody who's making a deal in India, at least on the antitrust front, should be fairly comfortable with its understanding of some of these legal aspects, but definitely it is something that one should note. In terms of trends, I think the trends are again very similar to what you find globally. I think EU released a paper a year back on minority investments, that how minority investments are a matter of concern. Now that's something which is very peculiar to India, because if you see under the FDI policy, there are sectors which are only permitted to have 24% investment or a 49% investment, right? But those sectors, in those sectors, the foreign acquirer cannot have control. So therefore, we've seen situations where there's a 24% investment made, and there is an exemption under the Competition Act for investments less than 25%, where parties have made a 24% investment, but the Competition Commission of India has found that also requires a filing, because it was done with a strategic intent. And again, it goes back to the entire issue of how control is defined. So again, on those aspects, on minority investments, it's a global issue, and it's an issue that is there in India as well. So if you're making a minority investment, it does not necessarily mean that you fall outside the jurisdiction of the competition regulator in India. You'll have to sort of assess the facts and circumstances of sort of each case. In terms of the other sort of trend that we have seen, and I think something that I alluded to, is that we've only seen 2 phase 2 investigations, but in both those sort of investigations, the transactions have been approved and have not been blocked, and roughly they have been approved well within the waiting period. So that is something that's also given the larger M&A community something to cheer about, because that was originally a concern. And the remedial measures that has been provided is divestitures. So they have approved 2 transactions, and they asked the parties to make divestitures of certain assets, which, as Vaibhav alluded to in the morning, has also created an M&A opportunity. So, that's the second trend. The third sort of trend that we are seeing is that in sensitive sectors such as pharmaceuticals, the definition of the relevant market has been narrowly defined. So in the pharmaceutical sector, in a recent case, they defined it at the molecules level. So that's also something that one should be aware of. Now, what does all this mean for M&As from an antitrust perspective, it's very simple. I think when you're sort of doing the deal, the only thing that perhaps you need to do is to see that what is the antitrust impact in terms of timeline. And obviously, if you're in a bid situation and a deal certainty situation, you may have to assess, as an acquirer, you may have to assess whether you need a filing A and whether the deal will pass muster with the Competition Commission of India, and accordingly document hell and high water clauses or something around those lines. And similarly for board, when it's evaluating deals, it will have to consider the deal certainty, and at that point in time, antitrust concerns of a particular deal will also be taken into considerations while approving a transaction. So I think, Nishith, those are the sort of broad points on the antitrust part.
I think just moving fast forward, initial death and tax are always unavoidable, as they say, at this point in time, I would say. But what are the typical tax issues in cross-border M&As, and how those issues are dealt with?
Sure.
If you can be a little quick, that would be helpful.
Sure. So just I'll touch upon a couple of tax issues. I think the biggest tax issue which acquirers face in India is withholding tax. So just to give some background, the law in India is that if as an acquirer you are acquiring shares from an Indian, shares from either shares from a non-resident seller, then there is a requirement to withhold tax at the buyer level, which means, let's say $100 million is the purchase price and the capital gains tax on that $100 million is let's say $10 million. Then the acquirer is required to withhold $10 million, pay directly to the tax department, and the $90 million is remitted to the seller. Now the problem with this is there are certain tax treaties which India has entered into, like Mauritius-India tax treaty, through which most of the investments in India have been routed. These treaties give tax exemption to Mauritius residents when they sell shares of Indian company. But because of the unpredictable tax environment in India, the purchasers are afraid of not withholding tax because ultimately the tax liability is on the purchaser for withholding. So what happens is when the negotiations start, the purchaser want to withhold the tax, the seller does not want the tax to be withheld. And that's where the issue comes up on who will bear the brunt of the taxes of the seller. What we have seen over a period of time is 5 or 6 things which are alternative, and the parties choose one of the alternatives. The first one and the most common alternative is the tax indemnity, which means the purchaser do not withhold any tax while making payment to the seller, especially if the seller is from Mauritius, and an amount equivalent to the tax is taken as there is an indemnity which is given by the seller to the purchaser for that. This is most common. I would say about 8 or 9 out of 10 transactions they go with tax indemnity option. Second option is to either go for an escrow or a holdback type of structure, where the amount equivalent to tax is held back and put it in an escrow account, and as and when there is a determination of the tax liability, the amount is either released to the buyer or the seller. Again, not many transactions happen this way. The third is advance ruling. So in India, we also have the concept of private tax ruling, which you can approach the tax department for a proposed transaction and get tax certainty for that transaction. This used to be an effective tool few years back, where the where the authority for advance ruling was pronouncing rulings within 6 months' time, and it was easy for parties to predict the tax rate based on the ruling. But unfortunately, over the last couple of years, this time has extended to 18 to 24 months, which means the parties cannot wait for the authority for advance rulings to pronounce a judgment, and hence this particular option has not been very effective of late. On top of that, what we also seen is that tax opinion is taken from the seller's legal counsel for similar transaction to get certainty, that at least there is a law firm which is advising that there is no tax on the transaction. So broadly, this has become a big issue. As part of this issue, one of the other issue which we have seen is when there are private equity funds which are the sellers in the transaction, The bigger issue which comes up is from a tax perspective, the tax department can come after the transaction for a period of 7 years from the end of the financial year in which the transaction took place. Now, most of the private equity funds, as you know, have limited life of 8 to 10 years, and most of the exit happen at the fag end of the life. So, when the fund has already crossed 6, 7 to 8 years of its life, they exit, and then they only have 2 to 3 years left in the fund life. Now, even if you go for a tax indemnity option, the problem which comes is because the tax authorities can chase the buyer for a period of 7 years and the fund life of the seller is getting over in next 2 to 3 years, how do you take care of the balance 3 to 4 years? Because if there is no fund, there is nobody to chase. You can't chase the LPs for the taxes. So the GP, which is the general partner for the fund, whether he will take the he will bear the brunt for the taxes. Will he use a clawback clause from the LP in case the tax demand comes up? So all these issues come up, and one of the solutions which has been found over a period of time in the last 5 to 6 years in India is tax insurance, where what we have seen is an insurance company. It gives insurance for the tax for the seller, and once the insurance company is giving it, the premiums have traditionally range from 5 to 7% of the tax cover which you take, but those premiums have now increased to 10 to 12% because of the uncertainty on the tax which has been affecting the India deals. But this has been an effective way of handling the tax issue, where neither the buyer is worried nor the seller is worried, only the insurance company is worried. Once you pay the premium cost, the insurance company takes care of that. So this is one issue which we see in all the deals. Almost 30 to 40% of our time while negotiating deals goes in negotiating tax indemnity, because this is a very complex issue, and both the buyers and the sellers are right in their own way, and we need to arrive at a middle ground to ensure that the deal doesn't suffer because of that. The second major issue which we have seen is in case of leverage buyouts. Now, there is a big myth which people have that in India you can't do a leverage buyout. That's wrong. In India, there are structures which you can use to do a leverage buyout. What is not permitted is the Reserve Bank of India doesn't allow the Indian banks to lend for acquisition financing, and that's why the myth is that you cannot do a leverage buyout. But that issue is there only with respect to bank funding. If you are an overseas acquirer, you can still push down debt into the Indian company, and that Indian company can use that debt to acquire business from other company. Now, the benefit of this are, there are many benefits to this. One is, once you push down debt, the Indian company's taxable profits reduce because you can pay out coupon from the Indian company to the foreign parent. Once that happens, you're almost looking at a 30% tax saving at the Indian company level, because you don't pay that much corporate tax. Second advantage is the repatriation benefit. If you are pushing debt, you can, and if there are cash flows in the Indian company, you can repatriate the money by redemption of the debt or repayment of the debt at one go, rather than waiting for tranche payout if there is an equity structure. The third advantage is you can create security for through the debt structure, which is not possible through an equity structure. So what we have been seeing is this leverage buyout structure we have used a lot for India deals, and it has been working quite well for the acquirer. The only tax issue which we face in leverage buyout, which again is an issue only for share acquisition, not for asset acquisition, is if you are using a borrowing to acquire shares of another company, the Indian tax laws say that the interest which you pay on the borrowing will not be a tax deductible expenditure, because it is used for acquiring shares which generates a tax exempt income. So you cannot get tax deduction for an expense if the source of that expense is for generating a tax exempt income. Now that's something also, if you structure it properly, you can still resolve that issue. But broadly, if you are acquiring a business of an Indian company, the debt push down structure has worked quite well. So these are the two major issues which we have seen in India deals.
Interesting. I think AAG is a forerunner in the insurance sector as well. And I guess how different are the scope of representations and warranties, disclosures, and other related deal items that you have seen in the Indian M&A space, and how different are they from your global practices? If there are some differences, that would be helpful.
Thanks, Nishith. Yeah, so the earlier discussion provided a nice introduction to...
yeah, you can also tell what you're doing.
Yeah.
A little more quickly.
So, very briefly, so yes, the tax aspect provided a nice vignette on how insurance can resolve M&A risk. So in terms of the difference in scope and reps and warranties that we're seeing in India versus what our experience is in the rest of the world, if we backtrack a little bit, the product really follows investment trends. So inbound private equity has grown in the last 2 years in India quite significantly, and they have certain warranty scope requirements. But the other point that sort of overlays our risk assessment and which flows through to the reps and warranties is buyer's remorse is a dynamic that results in claims for us. So we are very keen on trying to understand how adapted a buyer is to the prevailing Indian conditions of the business and how that integration is going to work after the deal is completed. If they have a mismatch in expectations, that produces a dynamic of buyer's remorse, which may result in what we call laundry listing, which is where a buyer would go through a process of trying to find a claim under a policy. Now, if you backtrack to what is a policy there for an insured in an M&A context, it really exists so that the buyer has certainty that if an unknown, i.e. something that couldn't have come out in diligence or couldn't have come out through disclosure, ends up resulting in a warranty breach and causes loss to the buyer, that buyer has recourse against the insurer to claim for their loss suffered. So for private equity especially, going into India, they will have certain reps and warranty requirements. Because of the way the legal industry is structured in India, there will often be very good, very local advice that can advise them on the local aspects of Indian M&A documents. So we understand and recognise a lot of those concepts in the reps and warranty scopes when we're reviewing Indian-governed W&I and Indian-governed SPA documents. So I guess from a very local aspect, what we do see as a key difference is fraud and ABC warranties are a very hot topic for warranty scope. White-collar crime, escrow is quite a different beast in India as compared to the other jurisdictions that we write policies in. Some of the issues for the fraud warranties in particular, it is a standard exclusion of ours for India and for many emerging market jurisdictions. The explanation for that is it's impossible to underwrite, and especially in India what we've found is obviously disclosure under those types of warranties is almost impossible due to the nature of those warranties. But secondly, the regulatory involvement and the regulatory scrutiny that's undertaken in India at the moment seems to be quite a reactive kind of effort from the local Indian governments as a result of various political pressures. So it's very unpredictable, it's very hard to diligence, and that's why we exclude it, unfortunately. Now, in other jurisdictions, that's the same, so there's not a lot of difference there. Other global practices that could contrast against India, we find that the scope of warranties is generally larger and more detailed. And for us, because it's an English and New York hybrid type document, we do have to try and shake off our sort of English perspective when we approach the underwriting of these documents and these policies. We do seek local advice and that helps, but we've successfully issued over 10 W&I policies in the last 18 months in India. So we certainly see there being no material concerns with a difference in the scope of reps and warranties which would prevent us from issuing further W&I policies. And I think the more experience inbound private equity investors get in doing Indian deals and making sure that their expectations as to what to expect post-completion are limited, it's just going to get easier and easier from our perspective.
Just to add to what Angus said, so I think one is the tax insurance, which I mentioned. But one of the things which we have started seeing in the last 2-3 years is a lot of Indian transactions are going for reps and warranties insurance. And this is a big change compared to what we saw earlier, because more and more sellers in India are founder individuals, and they don't want to take the risk of indemnification liability, which could go on for quite some time. So both the buyer and the seller, they have realized that and typically, Angus, correct me if I'm wrong, but the reps and warranty, the insurance premium doesn't exceed more than 2%, right? It's typically 1.5% to 2%. That's what we have seen.
Yeah. I mean, I'd say that the range would probably be 1.5% to 3%. But yeah, I mean, taking that.
Yeah. So that way, again, it's not very expensive, and it addresses the issue of both the buyer and the seller. So that's something we have seen in India recently.
Yeah, and just to add to that, I think the two main points about W&I insurance, and it equally applies to any other jurisdiction, is there is the risk management point, which has obviously been a key point of discussion in this panel, but also the strategic element to the product, which I think buyers and sellers are slowly catching on in India, and that is that the seller can achieve a clean exit, return funds from their sale of that investment to their shareholders, and walk away or reinvest. Whereas before, because escrow is quite a common holdback type method in India, W&I insurance does away with the requirement for escrow. As I said earlier, the buyer will have recourse against the insurer, not against the seller.
Yeah, and also, I mean, I'm sure people have been reading about the recent Daiichi-Ranbaxy concern, where an acquirer may not necessarily be comfortable, especially when there are individual promoters selling out, on the wherewithal of the promoter and the financial ability of the promoter to actually cough up or make good the indemnity claim. And where I think the insurance product really works well. One is because it is in line with global standards, and second is you eliminate India enforcement related sort of risks because the insurer is offshore. So you remove the India enforcement related risks, quite significantly.
Can I ask you, what are the deal terms that are very heavily negotiated,
Thank you.
And has there been some evolution of some new practices or different practices here? Thank you.
A lot of new, I mean, most of the agreement gets completely negotiated in India, but I will pick on a few terms which we see in India and how it is different here from here. So I think the first question always comes up is, how is the value defined? What we see in India is that generally it's on debt-free, cash-free basis. Is more or less what we are seeing, especially in certain tech deals. In sometimes there is a component of working capital required, which means that when you calculate the cash-free, debt-free basis, you will need to provide for a working capital requirement also. We are now seeing a lot more lockspot kind of a deal, and often there is always a pre-closing adjustment which happens to the value of the deal, and with the provision of a post-closing adjustment. And a lot of negotiation goes back in how this pre-closing and the post-closing adjustment work, what it will include, what it won't include. For example, tomorrow if a company gets tax refund, and because in India tax litigation is very common, invariably you may have paid tax under protest and you would have a litigation going on, and you may get a tax refund, whether it should be considered as a part of adjustment and how it should work. So a lot of those factors go into pre-closing and a post-closing adjustment factor. Second point where negotiation happened is on material adverse effect clause, the MAE clause. In the MAE clause, we have seen in recent past it's a lot more seller-friendly than buyer-friendly, but often what goes into defining what is a material adverse effect, the definition itself is a hotly negotiated aspect. The third where we have seen negotiations going on is on earnout, on how earnout actually will structure. Nishith mentioned in the first panel that deferred payment in India is something which is not automatically possible. Reserve Bank of India, especially when it's a cross-border transaction, Reserve Bank of India does not permit on an automatic basis deferred consideration. So there are various ways to structure it. However, recently what we are seeing is Reserve Bank of India has recognized that deferred payment is something which is part of an M&A transaction and has started giving approval much more easily than what it used to give before to a deferred transaction. In fact, last year we did a transaction where there was a deferred consideration and an escrow which lasted 18 months, and the escrow in terms of tax went on 7 years, and we were able to obtain approval from the Reserve Bank of India for that particular transaction and deferred payment. What principle they are using now is, as long as the Indian sellers, Indian shareholders who are selling the shares, if they get the fair market value as a part of their immediate payment, and the deferred concept is over and above the fair market value, then they will generally approve. That's the concept we have seen. Having said it, often the issue on earnout also comes from tax perspective, because what happens is that the moment a seller is selling shares and he's getting a partial consideration, and he has to pay tax on the full consideration, even though the deferred consideration is a contingent payment. And this creates some kind of problem on the earnout concept, which is something which sellers do not like, because they may end up paying tax on something which they may not get later on. However, there have been ways, structures which can make it work, and that's something often is negotiated. Fourth point is on reps and warranties, and what we normally see is reps and warranties is the whole sink is thrown on reps and warranties, and disclosures are exception to reps and warranties. Often the negotiations happen is whether the whole data room is a disclosure, or whether there are specific disclosure which are going to be addressed against each rep and warranty, and this is always a major negotiating point, and I have ended up negotiating every transaction I have done. More likely than not, today at least the trend is that the sellers agree for specific reps and warranties, specific disclosure, as opposed to the full data disclosure. However, the question then comes is that if the closing is happening at a later point in time, then whether the seller has a right to update the disclosure letter, and if they update the disclosure letter, what is the implication on the reps and warranties, because you don't want them to disclose something, and because you already agreed to a valuation, you don't have a negotiating power. So there is always a negotiations which happens at that point of time on how indemnification will happen for the updated disclosure letter. Now, having said it, coming to indemnification, which is a major aspect of negotiation, what we have seen on indemnification is, if you ask me this question 3 to 4 years ago, I would say the indemnity cap or limitation of liability indemnity is almost 100% or 1x of the transaction price. However, recently in the last 2-3 years, we have seen that come down to more of an international standard, and nowadays we are seeing anywhere between 15% to 35% is what our experience is on the indemnity cap. And with this indemnity cap, generally we'll see a de minimis and also a tipping basket. We don't see deductible anymore. It's very rare to see deductible concept anymore, but a tipping basket is generally accepted. My experience is the tipping basket is roughly 1% of 0.5 to 1% of the transaction value. That is what we have generally seen. The question which comes up always is, if private equity is selling as a part seller and promoter is selling, private equity generally does not give business reps. They don't give company reps, and as a result, promoter is or the founder is held with the company reps. And in that case, how you are going to get the proper indemnification becomes an issue, and that's often the insurance kind of goes and helps on that particular one. Also, in terms of time frame, what we have seen generally, the demand is 3 years for all reps, for reps to survive, and for indemnification to survive, and for tax it goes to 7 years to 8 years, 7 years after the transaction has been over. Now, having said it, we are now seeing more going down from 3 years to 18 to 24 months is what we are seeing now, but still you will find the buyers negotiating to 3 years, and more or less you will see between 24 months to 36 months is becoming more and more approved. I think we are running short of time, so I will stop here.
Yeah, but let me turn to Angus for a moment. I think, what is your experience in India? I think it was a profitable market. I don't think you had to ever pay anything for the tax indemnity purposes or
No.
I don't know what.
So just to
It
briefly
would be
touch on...
interesting to know because I think lots of people got insurance, but I think Indian judicial system has always helped you, hopefully.
Yeah, well, it's somewhat of a vexed issue in many ways. On the tax point, so the London insurance market has struggled to insure Indian tax in the past 5 years. There's been a diminished appetite. That is changing, I think, and this does cut across M&A transactions as well, but I think a lot of significance has been placed on the India-Mauritius DTA and how the Indian government has treated that. Obviously, there have been some good sounds made and some good judicial pronouncements recently, the Blackstone decision being one of them. However, I think the complete kind of conclusion of this issue hasn't really eventuated just yet. So the investment community, as our insurers, are waiting to see what happens. But more specifically to your question, Nishith, so just to hit on some of those points that I think the audience may find interesting to know, sector-specific risk analysis from our perspective, and this is really a general comment, not just related to India, pharmaceutical deals are considered to be higher risk, financial services are considered to be higher risk. Anything that is in a regulated industry is considered to be higher risk. Now, the degree of risk is an interaction or a function of how regulated that market is and how proficient the regulator is in enforcing the law. India, I think from our perspective, what can be said about the regulator in India would be that it's unpredictable, but it is overall relatively professional. If you're talking about an India-wide company operating across states, there is a lot of difference in how certain regulation can be between Indian states. So that is something quite difficult for us to underwrite. And to be honest, we haven't had as much experience in those kind of national Indian deals operating between states that we'd really like to have if we did come across a deal like that. So just going through my other talking notes just to cover off, to give you this flavour here. In terms of deals that we don't write in India, we generally follow the investment community's investment thesis. So if there is demand from inbound investors to certain segments in India, then we would generally track that, and that's natural because those parties will be the party seeking insurance. I guess the key thing for us as to what we wouldn't underwrite and what we wouldn't insure are very small Indian deals. So I think anything under about 30, 40 million USD in terms of enterprise value or deal value, we wouldn't insure. And part of that is because the economics of that transaction don't really stack up from a DD or due diligence perspective. There is not enough value in the transaction to undertake a full and thorough diligence by the buyer, and therefore it may be that the insurer is being asked to step in and cover issues that the buyer should have found out in undertaking a reasonable due diligence, remembering, of course, that the product is therefore unknown unknowns, being things that you couldn't have found out. Claims is always an interesting point for insurers. AIG will be releasing a global claims study in the next couple of weeks on our W&I global book. As part of that study, certain stats will be released, and to contrast what our experience is in India, for deals of under 100 million USD, we're looking at about 15% of those deals resulting in claims. That would be slightly more than what our Indian book of insurance is. Now, it does vary region to region, but I think the key kind of factor in whether we get a claim or not is not actually where the risk is located, but the deal size. A comment was made earlier that the bigger the deal, the riskier the deal. We would agree with that, although in terms of number of claims we've received, we do seem to receive those claims on deal value of about 100 million or less. Partly a function of that is the main kind of deal size that we insure, but the stats really don't lie. It does seem to be playing out that deal size, we're receiving more claims than other deal sizes. Another point to note, just talking about the process that we get involved in. So we would generally be approached by a broker, an insurance broker, to procure insurance at about the stage where the buyer has either issued or received the first draft of the SPA. Obviously, we're insuring the warranties and the indemnities, so we'd want to see those and try and understand how much flexibility there is in the scope of those warranties and work out what the actual risk will be from a technical, legal perspective. But it's interesting to note, I think, that yes, it is all very well for us to underwrite the warranties and the indemnities in the agreement, but I think more importantly for the longevity of the market, the insurance market, the M&A market, is to understand what the actual core risk in the deal is, something that we term thematic underwriting, trying to understand what the business risks are, because in a negotiated SPA you will generally find that you will have a set of warranties that are fairly balanced. If there is a claim or loss in the company that will eventuate, it will eventuate pretty much regardless of what the warranties say. The way the warranties are drafted, you will find a warranty that you can run it through. So we're very keen on trying to understand what the themes of the business are, to try and understand what the risks that the business faces and how the buyer has diligenced for those risks and how they're dealt with through the eventual contract that they strike. So that's sort of covers off quite a few of those points that I've generally found people like to know about.
Yeah, but
Nishith,
Angus, just to add, I mean, in terms of tax warranties,
Yeah.
the only thing that you do not necessarily insure would be transactional tax and not really the tax reps and warranties that are given vis-a-vis.
Yes, that's correct. So transactional tax being a specific tax issue that is being insured under a specific tax policy. AIG, I mean, we are considering changing our position on that, and there's a fair amount of work going into it currently. But you're right, tax warranties in an SPA, pursuant to an M&A transaction, we will cover those warranties. It's a specific standalone tax issue, which is what us and the London market has generally found quite difficult to insure.
Excellent. I think one thing, Nishith, can you quickly deal with indirect transfer tax?
Sure.
Let's put it that way. It's slightly different from indirect tax, by the way. It's indirect transfer tax. So can you explain that very quickly?
Sure.
Delay one or two points and then have
Yeah,
questions.
so I think this has become extremely important since the last 3 years. This is what we also call Vodafone tax in India, and the law was changed in 2012 by Pranab Mukherjee, who is currently the president, when was the finance minister at that time. What this law says, and it's very important because not many foreign clients and lawyers know about this law, but it's very draconian. What it says is that if a foreign company's shares are transferred, so let's say a UK seller is selling a UK company to a US buyer, apparently you will feel there is nothing happening in India, Indian company securities are not being transferred, and hence we don't need to think about any Indian issue. But actually there are three issues which could come up because of this, which directly relate to India. One is the indirect transfer tax issue. So what the Indian tax law say is that if the value of the UK target is derived more than 50% from the Indian entity or the Indian subsidiary, then even if there is no direct sale of shares of Indian company, there will be Indian capital gains tax implications on the sale of the UK company. So in the last 3 years, we would have done at least 30 to 40 transactions which had no direct relation with India, but because the target which was getting sold had a subsidiary in India. And then we had to deal with all the tax indemnity issue which I just discussed, because the same rules apply even to indirect acquisition, where the buyer of the shares is required to withhold tax before making any payment to the seller. So this is one major issue, and the problem is the way the law is drafted is very ambiguous. There is no determination on how do you calculate the value, whether the value will be discounted cash flow, whether it will depend on the employees of the Indian company in IT sector. So there are a lot of uncertainty around this, and it's very important that when you are doing any global transaction which is an Indian piece, it's better to consult the Indian tax and legal advisors before you consummate the global transaction. Second issue which comes up is the competition law issue, where even if it's a global transaction, what we have seen is there could be potential competition law implications in India. In fact, in one deal we did, it was a distress buyout where the a large group was sold for $1. Now, if you look at the transaction, everything was happening outside India, but the target company which was being acquired for $1 had some operations in India, and the way the competition law is worded, we were required to make a filing with the Indian antitrust regulator. So that's again very important. Even if there is no direct connection, indirectly, if there is a connection, there is a requirement to file, make a notification with the Competition Commission. And third is, if you are acquiring a foreign company which has an Indian listed subsidiary, then the takeover code gets triggered based on the indirect acquisition rules. So because there is an indirect change of control which is happening outside India, there is a takeover code which gets triggered. So I think it's very important when you are doing global transactions, just take care of this tax, competition law and the takeover code issue, so that you don't have to, after consummating the transaction, you don't get notice from the respective regulator as to why you didn't make filing with that regulator.
I think I'll ask one last question to Ankit, I think, and then we'll open up for questions from the audience. This is a very interesting situation. What about shareholder activism? There's a recent buzz in India, and how is it affecting deals in India, if you can throw some light on that?
Sure. So, shareholder activism is one of those interesting aspects that's developed in India over the last couple of years. Now, let's step back a moment. Shareholder activism was something which was absent in India for two reasons. One was India, the corporate demography in India is essentially that you have a concentrated shareholding. So, there was no real interest for the minority shareholders to go against the majority and sort of make meaningful changes to a company. And the second aspect was there was institutional weakness. Now, essentially courts in India are plagued with a lot of cases, and it's really costly. It was really costly to enforce some of these, shareholder measures, right? What we have seen, I think, globally, and this is not just a phenomenon in India, but even in the US or UK or EU, is that post the financial crisis, there has been a tightening of the corporate governance norms. And as a result of this tightening, we have seen more shareholder engagement, and that phenomena has sort of caught up in India as well, coupled with the fact that the new age Indian companies seem to be having more US style, Western economy, diffused shareholding model, and as a result of which you're seeing some of these new trends, which is shareholder activism. So these, and as Nishith said earlier, that in terms of investor protection also, India is sort of stands on 8th in the World Bank Index. So it clearly shows that there are macroeconomic and regulatory features that are there in the Indian economy and the landscape today, which is leading to shareholder activism. Now, the anecdotal evidence on the ground thus far is that most of the shareholder activism has been limited to related party transactions, to executive pay, and has not necessarily affected deals yet. However, what we have seen in the last couple of years, at least in two instances, one which is still an ongoing sort of transaction, which involves the intra-group merger of Vedanta's subsidiary in India, which has some UK links. So, there we are seeing, a lot of questions sort of being asked by the minority shareholders. And the other was, Siemens trying to sell its stake asset in one of its metal sort of subsidiaries, and that also got blocked. Now, why are shareholder activism is a concern? Essentially, if you, as Nishchal explained, you could do M&A transaction in three ways. One is asset acquisition, one is a merger, and one is a stock acquisition. In the asset acquisition and the merger space, essentially you require the approval of the shareholders. Now, this coupled with the fact that there is a peculiar sort of law that has developed, and this has also got to do with the concentrated shareholder sort of model that we have, is that you need the majority of the minority to to approve some of these transactions. Now essentially what it means is that if the promoter is related to a certain resolution, then the promoter cannot vote on that resolution, and you would need the majority of the non-promoter shareholding to approve the transaction. And therefore the shareholders today in India, even if they may not hold significant stake as compared to what you would generally find in some of the Western economies, because of this change in rule, have a meaningful sort of influence. And coupled with the fact that there is now the commercial courts bill, and there is an increased sort of effort made to strengthen some of the institutional framework, it does seem, Nishith, that shareholder activism will increase in the coming years, and it's certainly going to make an impact as far as deal making is concerned.
Yes,
Thank you so much.
So Nishith, just to add, I think in essence, in all we're saying today is that the role of the board plays a very pivotal place in the M&A scenario in India. Although previously, and if you see especially diligence, when you look at a diligence report, and when you look at board meetings, they seem to be sometimes paper minutes, and therefore people are concerned as to what they're really buying and how the decision making has actually happened. But I think a positive side, a special positive side to shareholder activism, and not just shareholder activism, it's also the legislation today which poses a lot of roles and responsibilities on directors, and how decision making is made, is that things are no longer going to be just on the surface. It's going to be, I think things are moving towards more meaty discussions and more substance oriented, whether it's through tax reforms or tax laws, or Companies Act, or through basically just decision making. So decision making is being questioned, and shareholders today, even if you hold a 1% stake in the company or 2% stake in the company, you can still have a say. So investing into a listed company, investing into an asset class with a minority shareholder doesn't mean that you have no say in management. You could have a say in management through these forms. Yeah.
Thank you so much. Any questions, any comments?
Yes, could I just ask one question, please?
Yeah.
Is Mahinder Khari again. Nishith, you were saying that if a UK company sold its shares of a subsidiary company in India to an American company, there would be a tax incidence in India. That was basically what you were saying.
Yeah, so it's not a UK company selling shares of Indian company. A UK seller selling shares of a UK company, and that UK company, if it has subsidiary in India,
Yes.
then that also will trigger a tax consequence in India if the value of the UK company is more than 50% derived from the Indian subsidiary.
Well, I could
So
understand.
this is a little strange, where you're not selling Indian company shares.
Correct.
You are a UK resident, you own shares of a UK company, and then you sell it to American or another UK resident. So it's a UK, entire transaction is in the UK, but if the company derives its value substantially, more than 50% from India, then even though you are a UK resident, even though you may have to pay capital gains tax in the UK possibly, okay, still India would say, okay, we are going to tax you. Not only that, but the purchaser of your shares of a UK company would also be liable to deduct tax. And those are some of the strange kind of things that have been brought into India after Vodafone case. I think that is how it is.
So even under the Vodafone case, there was a Cayman company which sold the Cayman company to a Netherlands buyer. There was no Indian transaction, there was no direct Indian transaction involved, but that Cayman target company which got sold had Mauritius entities underneath it, and the Mauritius entities had Vodafone SR, which is an Indian company underneath it. So what the tax authorities said is that you are just creating layers for the purpose of avoiding tax. What you could have done is directly sold the Indian company shares and it could have been brought under the tax net, but you are using overseas multi-tier structures to avoid Indian tax, and hence they introduced this concept of indirect transfer in 2012.
Well, I could understand what they were doing. All they were doing tried to save tax. I mean, when you buy goods from China, you're trying to save money. So effectively what they were doing, using the Netherlands holding company structure that exempts capital gains tax, they were using a Cayman Island company that does not charge any corporation tax. The question here is, how does the double taxation treaty would fit between the UK and India in a situation such as this, when you got layers of companies in between? And the objective there is either treaty shopping or effectively to increase your cash flow, which sounds legitimate. And if we are saying that, look, you cannot use a Cayman Island company, if we are saying you cannot use a holding structure, are we saying now that they are rendered immoral? They're definitely not illegal in here because they do allow legitimate exemptions. I'm not sure what India is doing. Is India saying that, hold on, transactions is abroad and we don't recognize any of the foreign tax concessions?
Sure. So in fact, this is a right question, and in fact, Vaibhav and I were discussing this morning. So this tax was introduced by Pranab Mukherjee, was the finance minister at that time, and since now he is the president of India, in one of the closed door meetings he admitted that this was my biggest mistake, which I committed 3 years back, because of which India lost its sheen as the investment destination. So this is something which the person who changed the law has acknowledged that this was a mistake, but obviously this is something which is earning tax revenues for the government, so the current government will not change because somebody else has already borne the brunt for it, and they will take the benefit of it by collecting more taxes through this. But what this law also says, it says that even if there is an indirect transfer, if the ultimate seller is eligible to get the benefits of the tax treaty, the government will respect his claim for capital gains tax exemption. So just because it is an indirect transfer, that doesn't mean that government is going to tax without giving any benefit of the tax treaty. So if you are structured properly, even if it's a multi-tier structure, if the entity which is selling the stake in a foreign company has a good tax treaty with India, then you again don't need to worry because you will still get the exemption.
So I think in other words, if Mauritius company selling another Mauritius company which has Indian subsidiary, you will still get tax exemption.
Yeah.
Well, the purpose of the Mauritian companies is exactly to save tax. Am I right, Nishith, in here? That's why people use that structure.
We can discuss this at length, but I agree with you that, but there are very few tax treaties which exempt capital gains in the hands of the foreign shareholder. And Mauritius being one, Singapore the other, Netherlands to some extent the third one, Cyprus is the fourth one. But barring that, there are not many treaties where there are exemptions, but this also creates its own issues. So this whole indirect transfer tax has created a lot of issues, including, for example, transfer is defined to mean, to include even pledge, for example, is creating interest in the security. That leads to capital gains in India. Look at a situation, if you are living abroad and you want to buy a house and you got the shares of a company, you pledge to a bank, right? Now, that's also considered as a transfer. And if the underlying assets of the company of the shares of which you are pledging has Indian property, you may or may not even know at times in case of listed or otherwise entities. So, bank will have to withhold tax. Again, that's a little problem. How will a foreign bank so enforcement is going to be another major issue here, and we can go on this debate. It's been going on since 2012 in India, and we'll be happy to carry forward at the time of cocktail, which I think is waiting for all of us. But anyone has any important pressing? Oh, okay. There are people downstairs, I don't know, but if you could be very quick.
A brief one. It's Nishith Desai from
Mayor
Brown. Just picking up on the character of the regulator. I mean, corporations understand the regulatory landscape internationally, there's regulatory risk, etc. Where you have complex, novel issues, this has become then obviously the challenge, and you can take various approaches. You can do nothing, roll the dice, pray, make an offering to the local deity, etc. Engage a good law firm and make good submissions. And as Angus would probably say, all of the above plus an AIG policy. My question is of the regulator in India. Certainly, my understanding is for some of them, and the CCIs, I think in a particular case, the turnover of the staff is rather high. And this can make it a challenge for the institution of the regulator to really gain knowledge and experience and become a robust regulator of the market. So my question of you is, what's your own view of the character of the regulators and your confidence in them addressing potentially difficult issues?
Sure. So let me try and attempt to answer that. Has there been a lot of turnover? Yes. The CCI is a nascent regulator, so we come with a problem already, is that it doesn't really have a lot of wisdom behind it. That being said, in the recent past, and it's the same for promoter-driven companies, it's the same for regulators as well, is that the chairman plays a very important role in how decision making really takes place. And if you see the CCI, sort of tenure and turnover, tenure of the chairman, it's been for a full 6-year period. So that has given some sort of stability in terms of how the CCI has been interpreting things. So is the menial staff, is the staff below consistently changing? There are pros and cons to that. One is the fact that they, even if they do recognize that problem, if you see the annual report of the CCI, there is a consistent emphasis on training, whether it's regular staff or not, which they give. So I think they do recognize that problem, and they're trying to sort of take care of that. But since direction comes from the top, and since today the chairman has been extremely clear in his communications on policies, leave aside that they are nascent regulators and they're trying to sort of learn, given the mistakes that they've made in the recent past, in various sort of decisions, they're trying to sort of learn, cast that aside. But the fact that the chairman has survived for 6 years and created meaningful precedent, I think is something that is worth considering, and I'm sure it's sort of going to go a long way going forward. The second chairman has been appointed now. Hopefully he'll sort of continue for his term as well. But I think that's one positive in the light of what we're seeing.
Just to add to what Simone said, if you see, she gave the example of Competition Commission. I can give you an example of FIPB, Foreign Investment Promotion Board, which is the regulator for inward investment into India. Before the new government came in, FIPB used to take cases only once in a month. So there was a huge backlog of cases which used to be there, and then they used to sit once in a month, and at least it used to take 3 to 4 months to get an FIPB approval. In case of certain sectors like pharma, people have also waited for 9 to 12 months. What happened after Modi government came in, and we heard about how the bureaucrats and officials started coming on time. They started doing this meeting twice in a month. So the same backlog of cases which used to be heard once in a month, they started hearing once in a fortnight. Because of which the backlog substantially got reduced, and today the average time for getting FIPB approval has reduced from 3 to 4 months to 1.5 to 2 months. In the pharma cases which used to take 9 to 12 months, we have seen getting approval in less than 1.5 months. So one is the attrition, but second is even the productivity of the staff was at rock bottom earlier, and with the new government, with Prime Minister himself pushing the officials down to work harder and to achieve results, we are seeing the regulators being more proactive and clearing things faster than expected.
Yeah, even the SEBI, for instance, has been...
Could I interrupt you for a moment? Because guest we are having at 5:15 downstairs, and I'm really sorry for... There is one more question you had, other gentleman. What was that question?
It's Manu Mohan from Mayor Brown. The question was on the tax conundrum. Foreign law firms, people working in foreign law firms also have this specific problem of when they travel to India, they are also, there's a tax issue there.
Yes.
Do you see this getting resolved, because it hampers deal making in one sense, because either the general counsel of that Indian corporation has to come over, because
Very
no
good.
associate is willing to go and work in India on that deal.
In fact,
or
I have dealt with this issue, and depending on the facts and circumstances, how you are structured at times and how you go about doing things, and there are situations where it should not be taxed. At one point of time, tax department was very aggressive and therefore went after the law firms as well. But today, the situation is that different treaties have different language. Swiss treaty had a different language, and UK has different, and the US is different. So, in the context of those tax treaties will have to be determined. And, maybe also how do you calculate number of days for which a professional is present and all those things. Slightly long question, maybe we can discuss at the cocktail. But I didn't want to, cut your question off. I really am sorry that we have to stop here. My apologies. And I must thank all the panelists for their valuable inputs. And of course, on behalf of the firm, I also want to thank Angus, especially to you. I also request Ruchi, if you can just present a small memento to Angus, and also to Linda and Clive and all the group that is here assembled. Thank you so much for all the help. Also my colleague Milind, he is a techno wizard as we call. He always puts a lot of technology in place and lets us move things very smoothly. This wonderful venue, I just must thank again to Law Society. And but most of all, I thank you all for taking time out to attend this event, and we truly appreciate. Of course, now I don't want to stand between you and the cocktails any further, and I request everyone to join us for cocktails at this time. Enjoy your evening, and thank you so much for being with us today. Thank you.